If you're considering trust litigation, or you've just realized that a dispute may be unavoidable, one of your biggest questions is probably, what does this process actually look like? I'm Ben Fox, a California trust litigator, and in this video, I'm going to walk you through the roadmap of a typical California trust litigation case, from the first demand letter all the way to trial, so you know what to expect. Every case begins with investigation and evaluation. Before filing anything in court, we review the trust documents, amendments, financial records, property records, medical records, and just about anything we can get our hands on before actually litigating in court. We identify potential legal claims, things like breach of fiduciary duty, failure to account, undue influence, or lack of capacity. Essentially, we ask ourselves the question, was something done wrong here? But just as importantly, we're also asking, is it worth pursuing? Litigation is a financial decision just as much as it is a justice question. We evaluate the amount at stake, the likelihood of recovery, and the emotional and financial cost of moving forward. This phase typically takes a few weeks, depending on how quickly we can gather documents and information based on what is actually available to us. If the case is merit, the next step is often a demand letter. This is a formal letter outlining the facts and law as we see it, and then demanding the other person comply, whether that's producing an accounting, repaying funds, stepping down as trustee, or engaging in settlement discussions. Rarely, but sometimes, a strong demand letter resolves the issue entirely. Other times, it clarifies that litigation is necessary. If informal resolution fails, we file a lawsuit, which is generally a petition in the probate department. In California, almost all trust disputes are handled in the probate division of the Superior Court. Once the petition is filed, a hearing date is set, and all interested parties are formally served with the petition. The first hearing almost never decides the entire case. Instead, it sets the litigation process in motion. Next comes discovery, the formal exchange of information between the parties. This is often the longest phase of the case. Discovery can include written questions, requests for documents, depositions of the parties and relevant witnesses, identification of expert witnesses, such as forensic accountants or medical experts, and subpoenas to banks, medical providers, or any other entity that might have relevant information. Discovery is where we gather as much evidence as we can to prove or defend against the claims. This process can take several months, or even more than a year for complex cases. Did you know that most trust litigation cases settle before trial? In fact, trust litigation is a unique area of the law where the court can actually order the parties to mediation. Mediation involves a professional mediator, a neutral third party who facilitates settlement discussions. A successful mediation might result in a financial settlement, removal or replacement of a trustee, or restructuring of how a trust is administered. If a settlement is reached, the case ends, and if not, we continue preparing for trial. Before trial, attorneys may file motions to narrow the issues or exclude certain evidence. If the case proceeds to trial, it is typically a bench trial, meaning that a judge decides the outcome, not a jury. At trial, witnesses testify, experts present opinions, financial, medical, and any relevant documents are analyzed. Trials can last anywhere from a day or two to several weeks, depending on the complexity of the dispute. After trial, the judge may issue a ruling immediately or take the matter under submission and issue a written decision later. As part of the court's ruling, the court may order repayment of funds, determine that a particular trust document is or is not valid, remove a trustee, or award attorney's fees. In certain circumstances, there is also the possibility of appeal, which can unfortunately extend the timeline further. From filing to resolution, most trust litigation cases take between 18 and 24 months. Some resolve much faster through early settlement. Highly contested cases can take longer. And here's something many clients don't expect. Trust litigation is often family litigation. It can strain relationships, it can feel personal, and it requires patience. At Fox Law, we approach litigation strategically, not emotionally. Litigation is a tool, not the goal. At every stage, we ask ourselves the question, is our case getting stronger or weaker? Is this financially rational? Does this move us closer to resolution or proving our case? Is settlement appropriate here, or is trial necessary? Our job is to give you clarity, leverage, and a clear path forward. If you're considering trust litigation and want to understand your options, the first step is to visit foxtrustlaw.com and schedule a no-cost initial consultation with one of our experienced trust litigation attorneys, so you can make an informed decision before committing to the process.